Hey everybody, 𝗂𝗵𝗁𝗄𝘆 here from Carson Law. Decided that we're going to talk to you today about breach of contract. As you know, Carson Law offers real estate, litigation, and some wills. So one of the areas where we see breach of contract arise is after a real estate transaction has fallen apart. One of the ways that a breach of contract can happen is when a real estate transaction falls apart. Basically, a purchaser is unable to close on their transaction. So what is the seller supposed to do at that point? Well, it's really important that the seller mitigate their damage. What does that actually mean? Mitigating your damages means making sure that you're relisting the property as soon as possible. One of the things that we've seen most recently is that the market is changing, and it's changing quickly. So we're stuck in a situation where a property that might have been valued one way at the time that original agreement of purchase and sale was entered into is not valued by purchasers in the same way. And so you want to make sure that you are re-entering that market with your real estate agent's advice as soon as possible. As a seller, once you've taken into consideration ways to mitigate your damages, you want to really think about what some typical damages that you'd be able to recover in a breach of contract action. And so we normally see the biggest thing being the difference in the purchase price. What was the original contract for, and what is the new agreement of purchase and sale that you've hopefully entered into quickly, and how much is the difference between those two prices? And what is the difference in price between those two contracts? The other typical damages that we see in a breach of contract would be things like your carrying costs. How much insurance do you have to pay? How much utilities are you paying? Do you still have interest payments on your mortgage? Was there a situation where you had to go and get another mortgage at a higher rate? These are all sorts of things that we have to consider so that we can figure out what does it actually cost you as a result of that purchaser's breach of contract. There's one thing that a lot of sellers don't really realize when they're entering into that agreement of purchase and sale that they can do to insulate themselves from being stuck in a position where they simply can't recover the amount of damages that they have from a purchaser. And that is having a sizable deposit on your original agreement of purchase and sale. For example, if I'm a seller and I'm accepting something in the amount of $10,000 as the deposit on that agreement of purchase and sale, that's only insulating me $10,000. So if I go and sell my property to a new buyer and the difference in the purchase price is $20,000, $30,000, $40,000, that deposit isn't going to come close to covering what my damages are. However, if I get a sizable deposit, something in the ballpark of $75,000, $100,000, or even more, at least at that point, the purchaser has some skin in the game, as they say, and it's a lot easier to recover money from a real estate agent's trust account as opposed to trying to hunt down a purchaser, which can get really expensive. So while I hope you never have to contact us because you find yourself in one of these breach of contract situations, if you do, you know where to find Carson Law. We're here to help you for your real estate needs, your will needs, your corporate needs, and of course, litigation and landlord and tenant matters. Give us a like on our socials, tell us that you're enjoying our content, and if there's a topic that you'd like to hear about, let us know.